Hello and welcome to the program. I am Deji. Now, Nigeria is currently at a risk of losing some of its assets worth $9 billion. In July, a British court granted permission to process an Industrial Development Limited P&ID to seize $9 billion worth of Nigerian assets over a failed gas contract dispute. Just to get an idea of how huge this is now, the sum would be one of the largest financial penalties imposed in Nigeria, representing 20% of the country's current foreign reserves. The court judgment was the outcome of claims that the Nigerian government unilaterally reneged on a 20-year gas supply and processing agreement reached in 2010 between the Federal Ministry of Petroleum Resources and the Irish company. P&ID alleges it had invested over $4 million on the project proposed to be executed in Calabar, Cross River State, southern Nigeria. Now, ruling on an arbitration case filed by P&ID in 2017, a UK court awarded damages of $6.59 billion in favor of the gas firm, with pre- and post-annual interest of 7%, increasing the figure to $9 billion. But the Central Bank of Nigeria insists that there are no records to prove this claim. In addition, the Attorney General of the Federation and Minister of Justice says the contract itself is suspect. Take a listen to this.
There are various options that you will adopt in bringing in your investment. If you're bringing in capital, in which case you are bringing in the money, you will fill Form A and you will also collect a certificate of capital importation. If you're bringing in machines or assets to execute your contract, then in which case you will fill Form M and also collect certificate of capital importation to prove that you actually brought in money. We have gone through our records. We don't have any information in our records to show that this company brought in 1 cent into this country.
The contract was originally designed to fail fundamentally against the background of the fact that there were inherent elements of breaches that were designed into it right from conception. When you conceived, sign and execute a contract for the supply of gas products without involving IOCs, NPDC, and NNPC as a party to that agreement, you know very well that there are a lot of questions to answer arising from the execution of that agreement.
Now, the government says it is seeking a stay of execution of the judgment and that it is also open to negotiation to resolve this logjam. Joining me now to discuss this is Falana, a senior advocate of Nigeria. Thank you very much for joining us on the program. First off, how bad is this contract now, the P&ID deal? How bad is it for Nigeria?
Well, it is bad that Nigeria has been asked to pay a whopping sum of $9.6 billion. But the government has some options. One,
9 billion actually.
Hello?
I mean $9 billion actually.
$9 billion. 9. Now, government has the liberty to pursue an appeal and ask for stay of execution for now. Because of course the judgment is going to be registered. Government may wish to oppose, the registration of the award on the basis of certain developments. And one of them for me is the ground of fraud. I have discovered that at the time the contract was purportedly executed and approved by the late President Yaradua. The president was not in a position to do that at the material time. That was when the president was said in January 2010, when the late President Yaradua was said to be in a state of coma in a hospital in Saudi Arabia. And that, if you recall, that was the time that our budget, the budget of the country was also forged by the cabal that had staged a coup and hijacked power in Nigeria at the material time. So if the government is going to prove fraud, there's a basis for it. I've also been informed very reliably that this company was actually set up in Nigeria purposely for this contract. It had not performed any similar contract in Nigeria before anywhere, and therefore the country did not meet the requirements of the law. I'm talking of the Public Procurement Act, because furthermore, such a contract could only be approved at the level of the Federal Executive Council, and it's been disclosed now both by ex-President Yaradua and the Attorney General at the material time, Mr. Michael Nduaka, SAN, that the contract, the agreement never passed through the Federal Executive Council. Hence, we have been told that it was President Yaradua that approved the contract. Again, as I said, President Yaradua wasn't in a position to do that. So if anybody had forged the signature of President Yaradua, that again has to be investigated.
But why do you think the government did not canvass these positions you have just identified now during the hearing of the case proper? I mean,
unfortunately, that is a question that we have to go to the government, including the fact that along the way, the Jonathan administration had already entered into some dialogue, and the company had agreed to accept as full and final settlement about $850 million. One way or the other, that was not taken up by the government. Hence, we are back to square one.
Is it going to be very easy to ask for a stay of execution in this case? Because what we hear is that, under this circumstance, in a case, arbitration case like this, is always very difficult to push for a stay of execution in the United Kingdom.
No, the judgment, this is an award of an arbitration panel. The award will still have to be registered as a judgment of the court in the United Kingdom for purpose of execution. Of course, the Nigerian government can raise some of these objections, some of these objections can be raised at that level. And of course, if we lose, if the judgment is eventually registered, of course, you also have the right to appeal. And both sides will have to look at the further expenses that will be borne, and then that may also force the two sides to agree to go back to the negotiation table. You have to look at your cost and try to cut your cost.
So either way, this is going to cost Nigeria some money, whether it's by settlement or by this judgment.
Well, this is the price to pay for official impunity. Once we do not operate legally, we got to pay a big price for it, and that is what is going on. And I do hope that this is a lesson for the federal government to review all pending cases of similar nature, cases that are pending in courts in different countries, as well as arbitration panels. There are some of them that may be worse than this one. So the situation in the UK throws a challenge to the government to try and review all pending cases, not just abroad, also locally. Government lawyers go to court many of the time at state and federal government level without any basis, no legal basis. Judgments are given against the government. Of course, in Nigeria, you can maneuver, you can dance around it and refuse to comply with the judgments of court. But you can't do that outside the shores of Nigeria. And that is what is happening to us.
Are you surprised?
Here, the government could just ignore the judgment, but you can't do that abroad.
Are you surprised that in drafting the contract in the first place, that Nigeria, back then the government would have accepted that the United Kingdom, or is it the United States now, should be the center for arbitration?
Of course, part of the problem of our country, United Kingdom, part of the problem of our country is that because there's a lot of confidence in our judicial system, people prefer to have contract executed or arbitration decided outside the country. And one other reason is lack of confidence in our own judicial system by the government. Once you have governments in this part of the world that have no regard for court orders, nobody wants to go to such a jurisdiction. Because what you do, when you are entering into a contract or you are taking your money to any country to invest, you are going to find out whether if there is a breach of contract, can I go to court? Will I get justice? Will it be expeditious? Will it be fast enough? Or am I going to remain in court for the next 10 or 20 years? So you have to move elsewhere. And so usually, people will insist on arbitration outside the country. And you can imagine the insult. A company has come from abroad to enter into a contract in Nigeria, to execute a contract in Nigeria. Yet our government allowed the arbitration to be held outside the country. This is a kind of insult, that our government takes from all manners of contractors and consultants all over the world.
What do you make of the view of the Attorney General of the Federation when he said the contract was basically designed to fail?
Well, I do not know the basis of his conclusion. Of his opinion. I'm not in a position to defend the Honorable Attorney General. That's his own opinion. But whether it was bound to fail or not, the contract was not executed, and government did not take any serious action. It's a failed contract, yet we have to pay monumentally for our own inaction, or rather official irresponsibility or impunity. But I'm saying this case should serve as a challenge to the government to review all pending cases against Nigeria, locally and internationally. Furthermore, all agreement being signed by the government should be supervised by the Federal Ministry of Justice. This one did not, from what we have been told now, never went through the Ministry of Justice. And then, even the Ministry of Justice will have to go out now and recruit lawyers who have the expertise in different areas of human endeavor. And once you do not do that, if there are problems for the country, you must go out and look for lawyers who have competencies in the areas that we are talking about. But what has happened over the years is that, agreements are never really vetted properly, and it's still going on. And once you run into such problems, the country will pay dearly. We are just talking about London, Paris club refund now. That's all we know about it. In one fell swoop, President Olusegun Obasanjo paid $12.4 billion without proper verification. At a stage, Nigeria didn't even know how much we were owing. So we had to engage the services of the creditors to tell us what we were owing. It was as irresponsible. So that is the dilemma we are in. So I expect the National Assembly to also put a mechanism in place where agreements that are signed abroad will have to be registered, will have to be enacted into law. Because Section 12 of the Nigerian Constitution provides that the government of Nigeria cannot enter into any treaty or agreement with a foreign country without domesticating and enacting same into law. But that never happens. I'm just reading now that the government of Nigeria is entering into a multi-billion-dollar contract with Morocco, for production of gas and, fertilizer and the rest. Now, those agreements are illegal. The treaties have never been registered by the National Assembly. They've never been enacted into law. And funds are already been expended. And what is more, I've just got a brief to sue the government of Nigeria on behalf of the Sahrawi Arab Democratic Republic, because the resources are located in the legally occupied territory of that country by Morocco. So the government will have to really be up and doing investigate circumstances of agreements, consult experts in relevant areas, and ensure that before an agreement is signed, it must have been properly vetted, and once it's bilateral agreement or treaty, you must go to the National Assembly, where apart from the executive, the legislature will also look at and vet the agreement before it is enacted into law.
Finally, sir, before I let you go, what's the worst case scenario for Nigeria in this case?
Worst case scenario? Well, as a lawyer, I really don't engage in speculation, but the worst scenario is that, okay, we're going to lose the case and we're going to be asked to pay the money. That's all.
Is it going to be easy for these guys now to just seize our assets?
Of course. Oh, that is done. Here, and that's why we get so relaxed with irresponsibility. Here, when you get a judgment against the government of Nigeria, you need the leave of the Attorney General to garnish the account of the government, to levy execution against the government. It's a colonial hangover captured in Section 84 of the Sheriff and Civil Process Act. I mean, which I'm just questioning. I'm just taking that section to the Federal High Court. I'm challenging the constitutional validity. If you lose a case to me, why must I now seek your leave to enforce the judgment? But that's what happens here, locally, not just at the federal level, in all the states of the Federation. So you have judgment debts running to several billions of naira, which are simply ignored by the government in Nigeria. But you can't do that. You can't do that outside the country.
Thank you very much, sir, for talking to us on the program.
Thank you very much. My pleasure.
Thank you, sir. We'll take a short break now, and we'll be right back. On Deji 360, we don't just ask the questions. What is wrong with amending the Constitution the way the National Assembly members have been doing it? We seek answers.
Constitution is constituent. Our problem is not lack of laws. Our problem is lack of the willpower to implement our laws.
Answers that provide clarity.
While we negotiate, we should try to make it a point that the girls must be complete.
The clarity you need to make informed judgment so that you can make the right decision and take action. People are saying it is you politicians that are responsible for this, that you are the reason why this is happening.
All these dollars that call themselves governors in this country?
I wish we had people like Tony at the National Assembly. God forbid that I go to join that
Deji 360, providing clarity to issues.